Thank you so much for joining us.
Sure, pleasure to be here.
So I want to get started because obviously we're talking about this Dugan trial set to start on the 15th. I kind of want to walk people through what we expect this trial to look like.
So I think the trial will be interesting because I don't think you'll see a lot of factual disputes between the two sides. You're going to see probably a lot of testimony put on by the prosecution that involves the federal law enforcement agents that were involved in the case, as well as different court personnel who were in the building, folks who were inside of Judge Dugan's courtroom at the time as well. It looks that their list of witnesses is pretty exhaustive. And I think there'll also be some video footage, perhaps some enhanced audio about what the conversations were in the hallway between Judge Dugan and the officers. And so I think you'll see a very thorough depiction of all of the events of that day. What will be in dispute, really, is whether Judge Dugan's conduct actually falls under these laws, these crimes that she's been charged with, and even more specifically, what was her intent in confronting the ICE agents? Was it for a corrupt purpose, or did she have a legitimate reason for confronting them in the hallway?
And I want to talk too about what you think the arguments will look like on both the prosecution and the defense side of this case.
So I think the prosecution is going to push the idea that what she was doing was irregular, that this was not the way she normally ran her courtroom, that she did things that day that were not things that she did in the normal course of business. And they're going to argue that that demonstrates that she had the intent to aid this individual who they were attempting to arrest, that she was attempting to aid him in getting out of the courthouse without being arrested, running some type of interference on his behalf. And so that's what the prosecution is going to try to say, is that her behavior indicates that she was making this attempt to disrupt the efforts of ICE to take him into custody. I think the defense will counter by saying two things. One was that Judge Dugan was legitimately concerned about these types of arrests happening in the courthouse. They had already happened on several occasions, and there was an ongoing conversation between federal law enforcement and the chief judge about how these apprehensions should take place, if they're going to take place inside the courthouse. And so Judge Dugan's reaction to this occurring may have been based, from the defense perspective, in a legitimate concern about the safety of individuals who are inside the courthouse, about a potential chilling effect that these arrests could have on participation in court cases. And so the defense is going to, I think, argue very strongly that she did not have a corrupt intent. It was just the opposite. She was trying to make sure that what was happening was lawful, and that what was happening in that courthouse was safe and regulated. And the other thing I think that they will add to the mix is that when she was inside her courtroom, adjourning this case, handling this case that was in front of her on her docket, that she should be entitled to some level of immunity for the actions, the official actions she takes as a judge. So deciding when, how, where to adjourn a case, these are all things that judges do every single day in their courtrooms, and they do them to manage their calendars. And so the idea that the way in which she chose to hear a case, or the way in which she scheduled a case in the future, that could fall under a federal criminal statute is something that I think the defense will renew their arguments about some form of judicial immunity.
And of course, we're seeing national attention for this case. I talked to some judges here in Dane County who brought up the kind of a similar point that you just mentioned, that this kind of brought up that conversation of what power do judges have in their courtroom. You mentioned intent numerous times, and I want to kind of dive into that topic too, about why intent matters so much here.
So in almost any criminal case, there is an element of intent. There's a mental state that the prosecution has to prove, that somebody did something intentionally, knowingly, recklessly, because we typically don't criminalize behavior that is accidental or unintentional. And so in this particular case, one of the charges requires that Judge Dugan have a corrupt intent. And so that's going to be, I think, a focal point of both prosecution and defense arguments, because again, I think they'll largely agree on the facts of what occurred that day. But from the prosecution's perspective, they're going to argue that no, Judge Dugan, in deviating from her normal course of business by confronting the ICE agents outside of her courtroom, that she had a corrupt intent, that intent was to help this individual evade federal law enforcement. And again, the defense is going to counter that no, she didn't have any type of corrupt intent. She was upset about this enforcement action occurring outside of her courthouse for good reason. She was seeking clarity about what the agents were doing, why they were there, what their intentions were. And so she didn't have a corrupt intent. And so in almost every criminal case, one of the hardest things for the prosecution to prove, and one of the things that juries really have to wrestle with, is what was the person's intent? What was in their head? We can't look inside their head and know. And so the jury will make inferences from the evidence that's presented in court about what her intent was.
So this really seems like the crux of this case here.
Yes, I think it is, because again, we know from audio recordings, from video footage, from all of the testimony, I don't think there's going to be a lot of factual disputes about what occurred on that day. The dispute will be about what inference can we draw from Judge Dugan's behavior, her words, on that afternoon. And that's going to be the crux of the case for the prosecution and for the defense, arguing about what actually was her intent.
And I want to ask, too, how common is it to see a criminal case against a judge like this?
This is an extremely rare case. When you do see criminal cases against judges, it is typically either for something that they did completely outside of the courthouse, right? A judge is pulled over and they're operating while intoxicated. Or you see cases brought against judges for some type of corruption because they were abusing their office, something like bribery. Again, those prosecutions are themselves extremely rare to see, but to actually charge a judge for something that they did in their own courthouse, outside of their courtroom, and partly while they were on the bench in their own courtroom, it is extremely rare to see a case like this.
And I want to talk to, because obviously a big part of this case is what power she had in operating her courtroom in the way she did. So I want to talk to a little bit about what legal powers judges have over their courtrooms.
So judges have general authority over their courtroom when they are sitting as a judge. They have the power to maintain order in their courtroom. They could hold somebody who's disruptive in the courtroom in contempt of court and fine them or jail them. They have discretion as to when they hear a case, the way in which they hear a case. Do the litigants have to appear in person, or can they appear remotely over Zoom or on some other platform? So judges have inherent authority to manage and run their courtroom and handle the cases that have been assigned to them. And this is one of those areas where that judicial authority seems to be running up against the prosecution's claims that she did something that violated federal law when they say, well, she adjourned the case with, and allowed this individual to exit the courtroom through a different door than what the public normally uses to come in and out of the courtroom. So, we're really seeing this overlap of an allegation where the federal case is built on this idea that some of the things that she did, it's built at least in part on the idea that some of the things that she did while acting in her official capacity as a judge were criminal. And that's the area where the idea, I think, of judicial immunity may resurface in this case. There was a motion made by the defense team early in the case to dismiss it on a claim of judicial immunity. That claim was denied, but in that decision, the judge left open the possibility that that issue could be revisited during trial, depending on what specific allegations the prosecution was relying on to build its case. And so I think you again may see arguments, I would expect arguments from the defense about the prosecution's case being at least partially built upon official actions she did while she was a judge that were not themselves illegal. They weren't like that she was taking a bribe when she was on the bench. She was just deciding how to adjourn a case. She was giving people access to her courtroom through a particular exit or entrance. And those are the things where, again, I think you'll see this argument that she has inherent authority as a judge to run her courtroom in whatever manner she sees fit. And that authority should shield her from an allegation that she was violating some form of federal law.
And I want to talk to you a little bit about this judicial authority, because depending on how this trial goes, I just want to get your take about if they were to rule against her, what this would mean for judicial authority and the power of judges over their own courtrooms. Is this something you think that we could see more cases spring up because this kind of sets a precedent in a way?
Well, I think the real concern from this case is that the law is that immigration enforcement is solely the responsibility of the federal government. Local government, state government, the judiciary is not under an obligation to participate with federal authorities when they enforce immigration law. The dangerous precedent or message that this case could send if Judge Dugan were somehow found guilty of one of these offenses is that if you are a judge, if you are any part of the judiciary, if you are part of the law enforcement community and at the state level, and you somehow don't behave in a way that facilitates the enforcement of immigration law, if you somehow don't comply with demands made by federal agents, that you are somehow in violation of federal law, that you are interfering or obstructing them in some way. And so, you know, that to me is the real concern about using these federal statutes in this particular way, is that I think it's calculated to send a message that you judicial officials, you state law enforcement officials, if we, the federal government, want you to do something, you need to do it. And if you don't, we'll bring a federal criminal charge against you.
And I want to just open up our conversation now too, because we've talked a lot about like different components of this case, but I wanted to ask if there was anything else that caught your eye that people should be paying attention to as we see this play out.
I mean, I think it is interesting that obviously the case has, the case was approached from the beginning, I think, in a very political way. Not just the decision to charge Judge Dugan, but the decision to take her into custody, arrest her on the courtroom steps, to see high-level, federal officers post it on social media, pictures of her arrest. None of that's going to be part of the trial. The judge is going to exclude that from the trial. But having said that, this is the type of case where it is shocking in some ways to see this become a federal criminal charge, a felony charge in criminal courts. And I can say from experience, I was a public defender in a very busy urban courthouse for a long time, and it was common for law enforcement agents to come to the courthouse to arrest people who had court dates because they were conducting an investigation. Sometimes it was for other federal law enforcement agencies would be there. They were aware that somebody had a court date. They would come to that court. And there was a respectful process that took place, which was that those law enforcement agents informed the court officers that they were there to make an arrest of somebody. The court officers informed the judge, they informed the prosecutor, they informed the defense attorney. They called the case. The defense attorney was able to talk to their client about the fact that they were going to be taken into custody. It was put on the record what was going to occur, and it was a seamless thing that happened all the time, and there weren't disputes about it, right? And it was partially because all of the parties involved were treating each other with respect and cared about the decorum of that courtroom, cared about the impression that they were going to give to people who were waiting to have their cases heard, that those law enforcement officers didn't want to scare people away from the courthouse, and so they conducted their business in a way that was unobtrusive and respectful. That's not the environment that we're in anymore. The federal law enforcement, immigrations, customs enforcement agents are entering courthouses in large numbers, waiting in public spaces. They're not doing the things that law enforcement used to do, which was treat the judiciary with a certain amount of courtesy, and that same courtesy was extended in return. And so this, to me, is something that should have been handled between the chief judge and the different heads of the law enforcement agencies who want to do this type of enforcement. This should not have been a federal criminal charge. This should have been a phone call. It should have been a phone call and an ongoing discussion about policies that meet the needs of everybody who is involved in this. And I have to say, you know, federal law enforcement officials have an argument here that they have an arrest warrant. A courthouse is a public space. They can make an arrest in a public space, and they prefer to do this at a courthouse because the individual who enters the courthouse goes through a metal detector. So they know the individual's unarmed. They can clearly identify the individual because he's appearing in court, and they're entitled to make that arrest. So I understand the point that they're making about this being a legitimate law enforcement interest to do these types of enforcement operations inside of a courthouse. But again, Judge Dugan and the other judges in that courthouse also have a legitimate concern. And that concern is doing the operations in a particular way could endanger other people inside the courthouse. It could also just have a chilling effect. And not just on defendants, and I think people should realize that too. When we say a chilling effect on who comes to the courthouse, yes, it might mean defendants don't show up for their cases, but it also might mean that victims who are not citizens might not show up. And it might mean that witnesses who are not citizens might not show up for court dates. And so that's the legitimate concern that Judge Dugan, I think, was expressing, that frustration that she was having about this larger issue about whether, not whether or not the officers could do this. It's really a question of whether they should, whether it's a best practice. And so it's regrettable, I think, that we are having a trial over something that really should have been a discussion amongst the judiciary, state judiciary, and federal law enforcement.
And I want to dive a little bit deeper really quickly into something you just mentioned at the end there, which is witnesses, victims not showing up to court because they are concerned about what that could mean for them. I know that, like I mentioned earlier, is something that Dane County is talking about now too.
Right.
Where do we go now from here with witnesses and these folks who need to participate in court not feeling safe to do so?
Well, I mean, this is the concern with aggressive immigration enforcement in or around a courthouse. That basically sends the message to people who are not citizens that the courthouse is not a safe place for you to be. It's a place where you could be taken into custody. And the consequences of that are that, again, victims won't come forward. And not just in criminal cases. You know, people who are the victims of things like wage theft or domestic abuse or other issues surrounding landlord-tenant issues, right? They won't come to court. They won't file a complaint. They won't seek redress for the rights that are being violated because they're scared of being in or around the courthouse, of involving themselves in any legal process where Immigration, Customs, and Enforcement can identify them as non-citizens and then show up at their scheduled hearing and take them into custody. And so, there's a balance to be struck on this, right? We don't want to close the courthouse doors to people who are victims, right? Just because they're not a citizen. At the same time, yes, federal law enforcement has a right to take into custody people who are not citizens and detain them, but again, there needs to be, I think, an ongoing conversation between federal law enforcement and state court judges and other administrators about striking the right balance on this issue so that people aren't scared of coming to court, but also honoring the fact that federal immigration officers have certain rights and responsibilities themselves and do have discretion to carry out law enforcement operations in a way that they think are best.
And this case certainly shines a light on a variety of different topics here.
It does. There's going to be a lot of debate around the case, and hopefully the case will encourage, I think, state court administrators and federal law enforcement to find some common ground so that we don't see a repeat of this federal trial.
Wonderful. Well, thank you so much for taking the time to come on and chat with us this morning.
Thanks. It's a pleasure to be here.